Thank you. We're here now in 1TA CV140621 in the Harvard versus State Farm. Each side will have 20 minutes for argument or appellant. You may reserve any portion of that time for rebuttal, but you'll have to keep track of that time yourself. We will be recording this argument both in audio and video. So when you approach the podium, please identify yourself and your client. At some point in the near future, the argument will be on our YouTube channel, so you'll be able to see how you did. We have read the briefs and the record, and we've confidence the case, so we're familiar with the facts and the law. So when you approach the podium, you just launch into your argument. Counsel, you may begin.
Thank you, and good morning. My name is Wayne Arnett, and with me at council table is my brother Mark Arnett, co-counsel in this case, and we represent Judith Indahar, the personal representative of James Indahar, who unfortunately was killed while this case was pending in the trial court. I wanted to first point out an error I made, and I'm not sure exactly how this happened, but when I filed my opening brief, my memory was that the motion for summary judgment that was filed in this case was filed on the issue of bad faith and punitive damages, as if punitive damage, and maybe that's my memory was that because we often see summary judgment motions for bad faith and a separate section of that motion for punitive damages. And in reviewing the actual motion that was filed by State Farm, it wasn't. It was simply a motion for summary judgment on the issue of bad faith. I agree with State Farm that if the bad faith claim summary judgment stands, so does our punitive damage claim. So do all damages relating to the bad faith claim. But the trial court did not consider, and State Farm did not ask it to consider, the separate issue of whether or not punitive damages would be available in the bad faith claim. That wasn't an issue we briefed. It wasn't an issue the judge decided. And unfortunately, when I filed my opening brief, I separated my discussion about bad faith and punitive damages based on my memory. And at my age, I'm going to quit relying on my memory. I shouldn't have done that. So I apologize for the confusion that may have caused. But if you examine, as I did yesterday in preparing for this, the actual motion that was filed by State Farm, it did not address punitive damages as a separate issue. And what the judge did, and what we're asking you to reverse, is his order that granted summary judgment on the bad faith claim. This case involves the interpretation of ARS 28-2091C. There aren't any reported cases interpreting that statute, but the interesting part here is that State Farm has been unable, both in the trial court and here, to explain exactly what language in that statute prevents it from doing what Mr. Indahar asked State Farm to do, and that was pay directly to Ford Motor Credit Company the amount, the balance that was due to them, get the lien clearance, get the lien released, and then a salvage title could be obtained, and then Mr. Indahar could be paid the balance that was due him, approximately $9,000. That's what he asked State Farm to do. And State Farm argues, and argued in the trial court, well, yeah, see that this statute, doesn't allow us to give money to Ford Motor Credit Company. I have, both in the trial court and here, asked State Farm, I'll do it again now, please explain what language in that statute prevents a lien holder from getting paid off. And there isn't anything. What it says is that the insured, the owner, it says, the owner cannot receive the total loss payment until the statute is complied with, until a salvage title is obtained. The statute doesn't say what State Farm did in this case is okay, which is not pay anybody. And that's really what happened. State Farm owed about at least $30,000. We say $38,000. We didn't agree on the value of the vehicle. But they owed that money, and Mr. Indahar had a right under his contract to keep the salvage. And what State Farm did was they said, well, if you're going to keep the salvage, we're not going to pay you, we're not going to pay Ford Motor Credit Company, we're going to pocket the $30-something thousand that we owe under the policy, and we're just going to close our file and go on about our business. And that was the state of this case when this lawsuit was filed. They had the money in their pocket and hadn't paid anybody anything. And Mr. Indahar brought this suit. And the first thing they did is they filed a motion motion to dismiss. And they cited the statute and said under the statute we can't pay any money to Ford Motor Credit Company or to Mr. Indahar until a salvage title is obtained, and he has to go out and find $20,000 in his own bank account somehow and pay off the lien, and if he doesn't do that, we don't owe him a dime. The trial court denied that motion very properly, and no appeal's been taken from that. That is not what the statute says, and there's no interpretation, no even unreasonable interpretation of that statute that will allow them to simply pocket the money they owe and tell Mr. Indahar to take a hike. And so, the interpretation, if there is one, has never been articulated about what in the statute prevents them from doing exactly that. And the interesting thing is, after this lawsuit, after the motion to dismiss was denied, State Farm did exactly what Mr. Indahar had asked them to do. They paid Ford Motor Credit Company, and then Mr. Indahar got a salvage title, and then they paid him the $9,000 in the rest of the undisputed portion of the claim. Now, if they really believe the statute didn't permit them to do that, they wouldn't have done that even after the motion to dismiss had been denied. Now, so the question on the bad faith claim, and that's the first issue here, is did the judge err in throwing out our claim under the duty of good faith and fair dealing? And the question is, did they have a reasonable basis for what they did? And I suggest to you they don't, and they can't articulate a reasonable basis under that statute for simply pocketing the money and paying him nothing. And the evidence is clear in the record that not only did they use a statute to deny this claim and to not pay anything, but they knew what the statute really said. And I took the deposition of Linda Osborne Jackson, the supervisor at State Farm, and I asked these questions, and this is in the record. You agree with me that it doesn't say in this statute that a lien holder cannot receive a portion of the settlement, a total loss settlement before salvage title? And her answer was, it does not say that a lien holder cannot receive payment. The statute says that the owner can't receive payment. And then I ask her this. So you agree with me that it doesn't say that he can't receive some benefit, like Mr. Indahar can't receive some benefit by the lien being paid off. It just says he can't receive a total loss payment, right? I agree that it says before receiving a total loss payment. And then this. Were you aware of that at the time when Mr. Indahar's claim was being handled? Were you aware of this wording in the statute? Answer, yes. The supervisor at State Farm admitted in deposition that she knew that the statute did not prohibit them from paying the lien off to Ford Motor Credit Company. And so we've got not only unreasonable conduct, but we have their knowing that their conduct was unreasonable because she was well aware of the statute and she knew it didn't prohibit them from doing what Mr. Indahar asked. I intend to reserve the rest of my time unless there are questions.
I have a question, Mr. Arnett. Is this a correct statement or not? On December 20th, 2010, Indahar told State Farm it could pay off the FMC lien and send him the balance, or it could send him the payout and he would pay off FMC.
Yes, he wrote to State Farm and gave them both options. And please understand, State Farm never said to Mr. Indahar, the problem is the statute. They never brought the statute up. They just simply said, you have to pay off the lien from your own funds before we will pay you any money. Okay? And so he suggested in his letter two options. You can pay me, okay, and then I'll go get a salvage title and I'll pay off the lien and then I'll send you the salvage title, a copy of it, or you can pay Ford Motor Company directly, okay, and then pay me later.
But one of the options that Mr. Indahar gave State Farm was not you pay the lien and then we'll take care of the rest.
Well, I believe it was, and I can probably find a copy of that exact letter, but certainly it was what he. First he said, why don't you just pay me? I'll get the salvage title, just pay me. And then he said, or pay Ford Motor Company directly. And then...
He didn't say pay Ford Motor Company directly and pay me.
Well, pay me afterwards is what he was saying. Certainly what was implied in that was that you would pay, he would get paid after the lien holder got paid and the salvage title was obtained, then they could do that. Certainly that was his intent. And I think it's clear from the entire letter that he was giving them that option, that we can get a salvage title here. You pay the lien holder, get the salvage title, pay me. Although he may not have said it quite that clearly, but yes. Unless there are other questions, I'd like to reserve the rest of my time.
Sure. Thank you, Counsel. Counsel?
Good morning. I am David Bell, and I represent State Farm in this case. On this issue of in the interpretation of ARS 28-2091, first of all, I submit it's significant that in plaintiff's opening brief, plaintiff concedes that had State Farm put in its December 2 letter wording to the effect that the statement that you need to pay off the salvage title to settle the case is based upon the statute, this lawsuit may never have been filed. In other words, the error here, they contend, is that the statute wasn't cited in the letter. And on this point, perhaps it would have been better practice for that adjuster in writing that letter, not merely to lay out the valuation of the claim, not merely to set forth State Farm's interpretation of the statute, but to cite the statute. Perhaps that's better practice, but as a matter of what's at issue here, was that a breach of the contract or a breach of the duty of good faith and fair dealing? The trial court correctly found that it was not a breach of the duty of good faith and fair dealing for State Farm to have relied upon that statute in not paying the claim at that time the way plaintiff was demanding it, but instead in telling him, essentially, if you want to keep the salvage, then under 28-2091C, before you're entitled, and the language of the statute is, an owner shall comply with the section 2091A before receiving total loss settlement from the insurance company. Now, their position is somehow State Farm paying Ford Motor Credit along the way before some net value is owed is not the owner receiving a settlement. State Farm take the entirely appropriate position that when State Farm is paying money on behalf of an insured to some third party to pay off the lien, that is, in effect, the insured receiving settlement, total loss settlement. State Farm interpreted the statute as saying it can't do that without receiving the salvage title.
Did it change its interpretation then after the complaint was filed?
I don't think it really changed its interpretation. What occurred after the complaint was filed was essentially defense counsel looking at the situation and say, how can I best deal with this case in terms of, do we keep on fighting over this issue? Can we disengage and get this cleaned up? And what you see here in this case is a decision that probably the best way to get this case resolved is to disengage the parties on arguing over the language, pay off Ford Motor Credit, because one thing is quite different in the context of litigation. Mr. Indahar, as an insured, is now in front of the court. If Mr. Indahar, if State Farm now pays Ford Motor Credit and the insured then doesn't get the salvage title, then State Farm's in the position to go back to the court and say, court, we're here, we're fighting about this, order Mr. Indahar to give us the salvage title. Now, the conundrum that the way this statute reads creates for the insurance company is that from the insurance company's standpoint, if you want to treat insureds in the same situation fairly and essentially in the same, then you have a situation where with Mr. Indahar, perhaps because he has an additional net amount owed to him, he has an incentive to go ahead and get the salvage title after his Ford Motor Credit is paid off. But from the circumstances of another insured who may not have that incentive because the net amount is much lower, or that would be owed to that insured, or there would be no net amount, what incentive that's created by the statute is really enforced on that insured to obtain the salvage title as a part of resolving the case? If the insurance company simply says, oh, that C doesn't prevent us from paying off the lien holder. So State Farm in this case made a very reasonable interpretation of the statute, where the statute lays out in subsection A that a process of paying off liens has to be fulfilled to obtain a salvage title. And then the statute in subsection C says the owner has to do that if the owner wants to keep the salvage. State Farm appropriately and reasonably interpret the statute to mean that Mr. Indahar, in these circumstances where he's insisting on keeping the salvage, has to get that lien resolved, and then because the lien has to be resolved before he gets the salvage title, and he has to present the salvage title before State Farm is paying on a total loss settlement. That was a reasonable interpretation. And once this was before the trial court saw that that was a reasonable interpretation of the statute. What State Farm did in the case was entirely consistent with that interpretation, and the court held that the plaintiff had not made a factual showing that there were issues of fact on his claim for bad faith. And so the bad faith claim was resolved by summary judgment being granted to State Farm. At that point, then, there was this remaining claim of breach of contract by not paying. The court didn't grant summary judgment on that claim, but at that point in time, we get into this interesting battle in this case about whether a dispute over actual cash value is a part of the case. And the discovery dispute that they go into is saying somehow the court erred in its discovery rulings and finally erred at the time in not granting the motion to compel and permitting plaintiff to amend the complaint. And what's absolutely clear in this case is at the time the original complaint was filed, there was nothing in that complaint alleging that State Farm breached its contract or breached its duty of good faith and fair dealing in how it reached the value of on that vehicle, coming to the determination that it was worth about $30,000. And in its December 2 letter to Mr. Indahar, it says, here's our valuation. If you disagree with it, then we can go to appraisal if you want to push that disagreement. And we even go so far as to name the appraiser that we would rely upon in that process. And despite State Farm doing that, there was no response at that time from Mr. Indahar himself saying, I disagree with that value. He's instead saying, no, just pay off what you think, and you will do it this way. And since State Farm was again reluctant or unwilling to pay Ford Motor Credit without Mr. Enderhart presenting the salvage title, State Farm reiterated, to Mr. Enderhart, you can take yourself out of this position, out of this deadlock position, if you waive your right to salvage. And we can then pay off Ford Motor Credit. We'll put the salvage into auction. You can purchase the vehicle from the auction. He flat out refused to do that. But on the value issue, that's what the issue. I mean, the value issue wasn't part of the claim at that point in time. Suits filed. Value issue is not part of the complaint. But once the summary judgment motion is filed, then as a part of responding to the motion for summary judgment, plaintiff is contending, well, I have this issue over value as well. And the court didn't expressly address it. It simply granted the motion for summary judgment. Plaintiff tries to do discovery related to the value issue and related to what would essentially be bad faith claims. We objected, or State Farm objected to that discovery. The court went back and forth, first of all, denying that. State Farm said, took the position, Judge, if you're going to allow this value issue to go forward, then you have to stay the lawsuit because the contract provides for appraisal. The court initially denied that. But when we finally got down to arguing a motion to compel that discovery, and we were in front of Judge Talamonte, who had previously ruled without oral argument, we're in court, and I'm making the point, Judge, this value issue is not part of this case. It's not pled in the pleadings. It's not stated in the disclosure statements. And the judge literally went over to his clerk's computer screen, read the complaint, and said, you're right. There's nothing in this complaint about valuation. The court allowed plaintiff to amend the complaint. The plaintiff filed an amended complaint. But now the valuation issue is stated in terms of an insurance regulation, that somehow State Farm violated AACR 26801H1 in how it went about valuing the claim. We filed a motion to dismiss. Anything based on that no cause of action can be based upon that insurance regulation as stated in ARS 24621D, as held by the court in Melancon versus USAA. Those insurance regulations are not the basis of cause of action. The court granted that motion to dismiss. An additional argument in that motion was the plaintiff was trying to rely solely on 26801H1 A and B and wasn't looking at subpart C that said if you're not going to provide a replacement vehicle and you're not going to value it in those terms, then as long as you have a written procedure that documents how you do it, it's an appropriate procedure. And that's exactly what State Farm had done by referring the matter to AutoSource and obtaining valuations from AutoSource. The court granted the motion to dismiss. At that time, I filed a judgment that did not include Rule 54C language because there was this lingering breach of contract claim that had not been granted at the time of the original motion for summary judgment. I knew it was there. Plaintiff knew it was there, but plaintiff responded to my form of judgment or State Farm's form of judgment in the case that didn't include Rule 54C language and said, no, we have to have Rule 54C language that makes this a final judgment and appealable now. That's what we filed. The court granted it. So insofar as the plaintiff now wants to argue that the court erred in entering a final judgment in this matter because there was this lingering breach of contract claim unresolved at the time of the original motion for summary judgment, that's now waived. The plaintiff could have gone and brought to the trial court's attention that there was that lingering breach of contract claim. Plaintiff, for whatever reasons, decided not to inform the trial court of that claim and insisted that a final judgment be entered. Insofar as the final judgment includes the award of attorney's fees, State Farm's position certainly is the amount and how the judge reached that determination is well stated in the brief order, but it is certainly within the court's discretion to have awarded those $20-some thousand in fees, and I really have nothing further to say on that unless the court has questions.
No.
Thank you.
Thank you, counsel. Rebuttal?
Again, Mr. Bell says, well, the statute, see, won't allow us to pay the Ford Motor Credit Company. That's not what the statute says. The statute isn't focused on what State Farm can or can't do. It's focused on what Mr. Indahar can or can't do. It says he can't receive the total loss settlement until he complies with the statute. It doesn't say Ford Motor Credit Company can't receive it. If that was the legislative intent, they could have said that. The statute simply doesn't say what they imagine it would say. And they know that. Their supervisor knew that when I took her deposition. She was aware of the wording of the statute, and that it didn't prevent them, under the statute, from paying Ford Motor Credit Company. But they didn't. Now ask yourselves why. They wanted to just pocket this money and force him to give up the salvage. He had already told them he had thousands of dollars that he had invested in this salvage, extra parts that he had put on, extra struts and a fancy stereo system and things that he could take out and put on a different car in which he had actually begun by the time all of this happened. But
Just on that
yes.
point, at least my reading of the record is that he was able to take all of the special parts and the enhancements.
He did. He took
out of the car.
He took those off of the car, and I'm not sure this is in the record, but he had actually purchased another car that did not have a salvage title, and he stripped off basically everything off of it, and then he sold after he took everything off, sold what was left for junk. I think that is in the record that he got $67 or something for what was left by the time he stripped everything off. But it was those expensive fancy parts that he'd put on this cherry Mustang that he wanted to keep. And he told them that he had invested like $15,000 in extra things on this Mustang. Things, by the way, that they refused to even consider the labor that it cost to put those in. For example, he had a real fancy stereo in there, and they refused in their calculations of his actual cash value to acknowledge that the stereo isn't just what you pay for it at Best Buy, but it also includes what you have to pay somebody to install it professionally in his truck, which he had done. And they said, no, we don't consider any of the labor at all, which is another issue that I presented on the bad faith, that they have a corporate policy of when you show I've got these additions to my vehicle, we don't consider labor. And they never really responded to that. Never really supported it. There's no case law that says they can ignore the labor that's put into a vehicle, because that's part of what makes the vehicle what it is. And those things like struts and stereos cost money to be installed. And he had those installed. If he's going to install them in a new vehicle, he's going to have to pay them again to get them done right. So that's part of our bad faith claim, and another reason why this judge erred when he dismissed the bad faith claim. He should, just on that labor issue alone, should have denied the motion and let this go to the jury on bad faith. An insurance company owes, under the Borland case, which we've cited, a duty to pay the undisputed portion of the claim. And that's exactly what Mr. Indahar asked them to do. Pay the undisputed portion of the claim, and then we can resolve the other issue in some other way, either maybe appraisal, and I want to get to appraisal in a minute. But they didn't do that. They just pocketed the money, closed their file, and said, if you don't have $20,000 sitting around in the bank, tough luck. We're going to keep the money and not pay anybody anything. And that was the state of the case until we filed this lawsuit. The motion to compel, it's true that I think in 4 different motions, the Judge Talamonte, seemed to be going with us on this one. He was denying their motion to strike with respect to the valuation claims. And what we wanted to do was figure out, how did they value this vehicle? What was the math they used? They gave us a report, but the report, as I pointed out in the brief here, doesn't tell us exactly what they did to calculate the value of this vehicle. I wanted to take the depositions of the people at AutoSource and find out what that was, and I sent a request to produce documents that would support their formulas. How the math is not a straight up numerical average of the 30 vehicles that they found, or the 27 of which I have no details on. 3 have some details, but it's not a average of those 3 or of the whole 30. There's some math in here I don't understand.
Counsel, as I understand the record, your client didn't dispute the settlement amount.
Well, he did dispute it. Absolutely, from the very beginning. And that's in the record. He sent them letters saying, you haven't paid me enough. It's in the claims file. I cited those in response to the motion. He did dispute it, and finally he said, pay me the undisputed portion, and then we'll go on. And what they said was, very clearly in response, if you don't get a salvage title, if you don't pay off the lien from your own funds and get a salvage title, we're not going to pay you anything. And if that isn't clear, then let me know. I mean, that was the tenor of their letters, was exactly what he said at the end of the letter. This isn't perfectly clear. They were not paying him a dime, but he never agreed to that figure at all. He never gave up his dispute as to the value. In fact, he gave them, and this is in the claims file and in the record, he gave them 3 comparable vehicles like his, and the average of those was $38,000. Instead of the 30 they valued his vehicle, it was $8,000 difference. And they rejected those by quickly saying, well, insureds generally cherry pick their comparable vehicles. Not that he did, no other analysis of them, and that was it. And so we had a dispute. He wanted $38,000 for his vehicle. They said it was worth $30,000. And that dispute has never been resolved. And I was never able to take discovery about how they calculated theirs. They were allowed to take discovery from my client and ask him questions in his deposition about those 3 comparables, about the equipment that was on the vehicle. They sent me a request to produce some documents related to that equipment. They were allowed to do discovery. I wasn't. Was never, I mean, the judge seemed to be, the judge was ruling with me on 4 different motions that I was allowed to take that discovery. And even in the final motion, he ordered them. He said to me to send over what you need, and he ordered them to produce it. And then they didn't produce it. They filed a motion to dismiss the amended complaint, and that was granted, and the judge told us in the order that he wanted to throw the whole case out and put Rule 54C language in it. That was in his minute order. That was the judge's ordering us to put 54C language in the judgment. The judge threw out the entire case. My case for evaluation, my case for bad faith. The judge did that. Now, Mr. Bell claims, this is my fault, that somehow I was supposed to guess that the judge made a mistake when he ordered Rule 54C language, and that I waived something by insisting that the judgment have 54C language in it so I could appeal. And that was the only way I could appeal, by the way. If that judgment had been signed, you would have dismissed my appeal, because it wasn't a final judgment, didn't have Rule 54C language in it. So I had to put it in a form so I could appeal it. But there's no question, in the judge's minute order, he said, give me a form of judgment, put Rule 54C language in it, and yes, Mr. Bell submitted one that didn't. He also submitted one that gave personal judgment against Mrs. Indahar, the personal representative. I had to fix that too. But that is not a waiver of my right to simply ask that the judgment have the language in it that had been ordered by the trial judge. And Mr. Bell never said to me or called me or wrote to me and said, hey, I think the judge probably messed up. Or he could have told the judge. He could have said, Judge, look, you got 54C language here. That isn't appropriate. We've still got issues in this case. This is one of those rare cases where the only argument that State Farm has been able to make that the judge, to support the judge, was that this was my fault somehow because I asked for the judgment to have the language that would allow me to come here and appeal. I've got 4 seconds. Any other questions?
No. Thank you, counsel.
Thank you.
We appreciate the argument, and today we'll take the matter under advisement and issue a decision in due course. We stand adjourned.